So here's a story that sounds ridiculous at first, until you realize it's exactly the kind of thing that can happen when a company moves fast, changes terms on the fly, and the customer assumes that a reservation means one thing, while the company later insists it meant something else entirely. A man put down $50,000 to reserve a Tesla Cybertruck. He thought he was securing priority delivery, locking in his place in line, and protecting himself from future price increases. Instead, he wound up in a maze of shifting paperwork, changed expectations, delayed delivery, a trade-in problem, financing confusion, and eventually a legal fight over a very basic question. What exactly did he buy? And that right there is the heart of the whole story, because companies love the word reservation when things are uncertain. It sounds casual, it sounds temporary, it sounds flexible. But when money changes hands, especially that much money, people stop hearing the word reservation and start hearing the word deal. Let's talk about it. This story begins with a guy named Daniel Mercer, a small business owner in Arizona. Daniel is not some speculator trying to flip a truck online. He runs a custom fabrication shop. He wants a Cybertruck because 1, he likes new tech, and 2, he thinks it'll be good for business branding. Big dramatic truck. Stainless steel body, everybody staring at it in traffic, company logo on the side. He figures it'll pay for itself in attention. Now Daniel had been following the Cybertruck story for years, like a lot of people. Delays, design changes, production rumors, pricing rumors, range rumors, the whole thing. But he stayed interested. And then one day, after talking to a Tesla sales advisor and reading what he thought were the right screens online, he makes a very aggressive move. He transfers $50,000, not $50. Not $100 placeholder. Not even the kind of deposit you see on some exotic cars. $50,000. Why? Because according to the version Daniel understood, this wasn't just a reservation in the casual sense. This was supposed to be an enhanced priority placement tied to a high-end configuration and early allocation. In other words, get to the front, get the truck sooner, reduce uncertainty, and maybe avoid whatever price chaos might come later. And if you're already hearing alarm bells, good. Because anytime a customer hands over a large sum based on what they were told a digital process basically means, you have the ingredients for a mess. At first, everything seems fine. Daniel gets confirmation emails. He gets app notifications. He gets the warm corporate language that modern companies use when they want you to feel reassured without actually promising very much. Your configuration has been noted. Your order is being prepared. We appreciate your patience. Your delivery timeline may vary, and that last phrase matters, because may vary is one of those phrases companies use the way magicians use smoke. It covers a lot of ground. Weeks turn into months. Then the first problem hits. Daniel logs in and notices that some of the language around his transaction has changed. What he remembers as a substantial priority reservation now appears inside the account as a combination of credits, order activity, and a non-refundable component associated with a vehicle configuration that is no longer described the same way it was when he sent the money. That is never a good sign. He contacts support. He gets one answer from one person, a different answer from another, and what appears to be a completely unrelated answer from a third. One tells him the money is tied to the vehicle. Another says it's tied to the account. Another says part of it may be transferable depending on whether a VN has been assigned. Yet another tells him pricing is subject to change until the final purchase agreement is executed. Now step back for a second. If you're the customer, you don't care how many buckets the company now wants to sort the money into. You sent them $50,000 because you believed it secured a specific commercial result. You believed it bought certainty. And if it does not buy certainty, then you begin asking the question customers always ask when paperwork gets slippery. Then what exactly was the money for? And then it gets worse. Daniel had arranged his finances around the original understanding. He planned to trade in his existing work truck. He postponed maintenance on that truck because the Cybertruck was supposedly coming soon. He turned down another vehicle opportunity. He even started promoting on social media that his business fleet would soon include the new truck. Then Tesla notifies him that the projected delivery window has changed again. At the same time, the final price appears to be different from what Daniel believed he had effectively locked in. Not wildly different, but enough to matter. Throw in taxes, fees, insurance impact, possible financing changes, and suddenly the whole transaction is drifting far outside the neat little mental box Daniel had put it in. So he asks for his money back, and that's where the real legal nightmare begins. Because the answer is not a simple yes. He's told that some or all of the money may be non-refundable. He's told that by proceeding through various digital steps, he agreed to terms and conditions. He's told the company did not guarantee a specific delivery date. He's told pricing was always subject to change. He's told reservation priority is not the same thing as a binding sales contract. And he's told, in effect, that if he misunderstood the nature of the transaction, that may not be the company's problem. Now, legally, this gets interesting very quickly. A lot of these cases are not about whether the product is good or bad. They're not even always about whether the company intended to trick anyone. Sometimes the whole fight comes down to formation, disclosure, and reasonable reliance. In plain English, what was offered, what was accepted, what was disclosed, and what was the customer reasonably entitled to believe. If the company says this was merely a reservation subject to evolving terms, but the customer can show that sales communications, interface design, account language, and the payment structure all strongly suggested a more concrete commercial commitment, then you start getting into the territory of consumer protection law. And companies hate that territory, because consumer protection law is where judges stop admiring sleek interfaces and start asking old-fashioned questions. What did you tell people? What did they see before clicking? What did the payment mean? Could a reasonable person be misled? Did the disclosures actually disclose anything? Or were they buried in fine print behind 3 screens and a cheerful button? That's the fight. Daniel hires an attorney. The attorney does what good consumer lawyers do, not just read the final contract, but reconstruct the whole transaction. Screenshots, emails, text messages, archived web pages, order summaries, FAQ language, app notifications, support logs, everything. And once they line it all up, the problem becomes obvious. The sales process was designed like modern e-commerce, but the stakes were old-school big-ticket commerce. That's a dangerous combination. Because if you're buying socks online, a vague button is annoying. If you're moving $50,000 based on a supposedly priority vehicle transaction, vague is no longer cute. Vague becomes evidence. Daniel's lawyer sends a demand letter. It alleges deceptive trade practices, unfair or misleading consumer communications, possible unjust enrichment, and detrimental reliance. Maybe breach of contract too, depending on what the documents ultimately show. But the strongest claim may not be traditional contract law. It may be the argument that the company created a commercial impression it later tried to walk back once the numbers and timelines changed. And let me tell you something, that happens more than people realize. A company will market certainty, collect money, and then, when reality gets messy, retreat into the fog of subject to terms, estimated delivery, account activity, non-binding reservation, and policy updates. Suddenly, the bold language gets small and the small language gets bold. Tesla, in this fictional story, responds the way large companies often do. It does not say, "Yes, we deceived him." No company says that. Instead, it says the customer voluntarily proceeded, agreed electronically, received multiple notices, and remained free to decline final delivery. It also argues that the reservation process did not guarantee final economic terms, and that any misunderstanding does not override the written conditions. That sounds dry, but it matters. Because in court, the company is trying to reframe the transaction from a promise with money attached into a customer-controlled process with optional next steps. Why? Because if it's the second one, then the company says Daniel assumed the risk of uncertainty, but Daniel's side says, hold on, optional next steps do not erase the meaning of the initial payment. If you ask a consumer for a massive sum and surround the process with language suggesting priority, access, allocation, and early delivery advantage, you may not get to hide behind, well, nothing was really final. A judge looking at this would probably focus on a few things. First, was the money clearly described, not just somewhere, clearly? Second, were the refund rules unmistakable before payment? Third, did the company's own communications create a misleading impression of what the customer was securing? Fourth, did the company materially change timelines, pricing assumptions, or transaction structure after taking the money? And fifth, did the customer suffer actual economic harm beyond mere disappointment? That last part is important. Courts usually care more when there's real damage. Daniel can point to tied up funds, lost alternative opportunities, trade-in disruption, financing consequences, business planning costs, and maybe even reputational embarrassment if he publicly represented that the truck was coming. Now, is embarrassment usually a big money legal claim? No. But it adds context. It shows the customer acted in reliance on the company's representations. Then, there's the practical problem every company should think about before letting situations like this grow teeth: jury optics. Imagine explaining to 12 ordinary people that a consumer handed over $50,000, thought he had meaningfully secured a highly anticipated truck, and then got bounced around through shifting explanations about what the money actually meant. That is not a great look. especially if the company's defense boils down to, well, if he had carefully parsed all the changing digital terms across every stage of the process, he would have understood that his very expensive reservation wasn't quite what he thought it was. Juries do not always fall in love with that argument. Now maybe the company settles. That happens all the time. Quiet refund, confidentiality language, nobody admits wrongdoing, everybody goes home irritated. Or maybe it fights, because big companies sometimes believe that refunding one angry customer invites 10,000 more. But the broader lesson here is bigger than Tesla, bigger than the Cybertruck, bigger than any one vehicle. It's about the legal danger of turning major purchases into app-based ambiguity. There's this modern corporate instinct to treat every transaction like software. Update the language, tweak the process, revise the terms, push a notification. But when real money is involved, especially large amounts, the law still expects old-fashioned clarity. You don't get to take serious money in a haze of marketing excitement and then act shocked when a court wants straight answers. And consumers, by the way, need to hear this too. A reservation is not always a contract. A deposit is not always refundable. A configuration is not always price protection. A delivery estimate is not a promise. And a sleek digital checkout flow can hide a lot of uncertainty behind very polished design. So if you are putting serious money down on anything, car, truck, boat, luxury item, pre-order, whatever it is, you need screenshots, you need the terms saved, you need emails archived. And you need to know before you send the money what happens if the seller changes the timeline, the price, or the rules. Because once the trouble starts, everyone suddenly becomes a historian. The customer says, "That's not what I was told." The company says, "That's not what the terms said." And then lawyers get paid to reconstruct who knew what, when. Which, in this fictional story, is exactly how a futuristic truck becomes a very old-fashioned legal dispute. Not over horsepower, not over towing, not over range, over paperwork, disclosure, and whether a company can keep $50,000 after the customer learns the deal was not as solid as he thought it was. And that is the kind of case that sounds small to people who don't deal with contract law until they realize it's actually about one of the oldest legal questions there is. When I gave you my money, what were you really promising me in return? That's the whole case. And if the answer is fuzzy, the legal trouble usually is not.